Good morning. My name is Starla Van Steenis, and I'm General Counsel for the Real Estate Commission. And I'm pleased to welcome you to the first Briefly Legal of 2022. And today's very exciting topic is going to be discussing the new rules of license law. As I was preparing for this, I was trying to research a quote regarding rules to either put in the title or in my introduction. But it seemed like every quote I came across was actually about breaking the rules. And although there was some good wisdom in some of those quotes, and I myself have broken a few rules, my job today is to educate you on what those new rules are. I also hope to relate to you that these rules don't come with a negative connotation that you think of when you think of rules, because sometimes you think with a rule something's going to be more restrictive. In fact, as we move through each of these rules, I really hope you see that the majority of them actually give you more freedom and guidance as a licensee. Please know that whenever you want to ask a question as I move through each rule, you're welcome to do so. Simply raise the hand icon on your team screen and that will let us know that you have a question for us. Before we get to each specific rule, I did want to kind of explain the process of how a rule ends up in license law. The Real Estate Commission has been given statutory authority to draft and put in effect rules and amendments. And this basically allows us to look at something that's already in the law and say, you know what, this may need to be further defined, it may need to be further explained. So if we see something that we think needs attention, then someone at the staff level will draft that new rule and or amendment. We then present it to the commissioners because only the commissioners can approve a rule or amendment to move forward. Once they have approved it, we then send it to what we call LSA, which is the Legislative Services Agency of Alabama, and they place it in their publication, the Administrative Monthly. And they place that in the Administrative Monthly on the last working day of each month. That new proposed rule is also placed on the Commission's website. We then have a public hearing, normally at the next Commission meeting, to discuss if anyone wants to come and discuss the rule. Another important timeline from the placement of that new rule in the Administrative Monthly is that for a minimum of 35 days, the public has a right to place a public comment regarding that rule. So once that's done, we then can, after the public hearing and after the fact that no one has come forward with any kind of public comments, we then place the final rule back with LSA. And they do a certification of publication in the Administrative Monthly. Once that is placed, that certification, then 45 days later, that rule then becomes a part of license law. So that's where we get to where we are with the new rules. So last summer, we started preparing a lot of new rules and putting them in front of the commission. So I want to kind of go over some of those new rules. So these were the ones that were enacted in 2021, and I've kind of broken them up by division within the commission. So the first rules I want to talk about pertain to education, and the first one I'm super excited about because I think it's going to be a great example of how a rule does not have to be restrictive. So under the prior law, without this rule, if a licensee wanted to become an instructor and they had any prior violations of license law, whether they pled guilty or found guilty, no matter how long ago, no matter how minor the infraction may be, they were basically barred from ever being able to be an instructor. Well, this rule now allows those licensees who may have an infraction in their background to come before the commission and plead their case to the commissioners. And the commissioners can then allow, after hearing all the facts, they can allow that licensee to move forward with to become an instructor. So this rule went into effect December 13th of 2021. And we've had one case come before the commission for this new rule. And that licensee was granted approval to move forward and she can now become an instructor. So this is just a perfect example that this rule actually opened a door that was closed before. So it was the opposite of being restrictive. A second rule that pertains to education was actually kind of a direct result of COVID. And again, you're going to see as I talk through this rule that this rule actually gives licensees a second option. And this has to do with distance education. So previously, if someone wanted to do distance education, we did what was called asynchronous learning. And that is when you basically would purchase a course and you would watch it on your own time on your laptop or your computer. And it wasn't a live instruction, it had been previously recorded. Well, we had to change up some things because of COVID. So now we offer what's called synchronous learning. And synchronous learning is when you're doing distance education, so it's still virtual, but the instructor is speaking to you live. So you're actually participating in a classroom activity, although you may be at home or at a different location. But we did need to come up with some version of, some parameters on this. So this rule basically addresses the fact that while you're involved in a synchronous learning situation, you can't be texting, you can't be driving down the highway, you have to be sitting there focused, you can't be doing other work. It also states that there has to be a moderator other than the instructor who's watching the students, because it's hard for the instructor to teach and watch and make sure everyone's paying attention. You can't be technically cut off from the instruction for more than 15 minutes. So this is just giving some guidance on how we expect licensees to act in a synchronous learning environment. And if any of these are not followed, then you can be denied credit for that particular course that you're taking. The final rule that has to do with, that pertains to education is regarding our military. So this rule, again, is one that is less restrictive than what was there before. So military can take real estate related courses, and they can take them through any branches of the military, the reserves, the the National Guard. So if they take one of those courses that are related to real estate and they want to give it to the commission to prove that it's part of their CE, they can now do that without us having to take an extra step of making sure that that course meets all of our criteria. So if it's approved by the military as a real estate course, then it's going to automatically be accepted for credit for that particular military person for their CE. So that's something that's very exciting and again helps our people that serve in the military. I now want to move to some new laws or new rules that pertain to licensing. So I'm going to move into licensing and the ones that pertain. The first one I'm going to talk about is actually another one that benefits our licensee that serve in the military. And this is another one that I'm just very excited about. So basically, if we're in a time of renewal and you are active military and you are deployed, if you simply give us your letter of deployment, you do not have to worry about renewing your license at this time. Instead, when you return from deployment, you will have until December 31st of the next year to renew your license and to complete your CE. It's just one of those things when you're actively deployed, there's enough stress on the active military person and their family that we do not need to add the stress of making sure your license is renewed. So again, a rule that I think benefits the licensee's community instead of restricting the community. A second rule that pertains to licensing has to do with our applicants that are homeschooled. Before, under the law, if you wanted to apply to be a licensee, there were only 2 documents you could provide to move forward with the application process if you were homeschooled. The first one was a certified transcript, and the second one was a letter from your homeschool group leader. Well, this rule now allows a third document, and that's your high school diploma from your homeschooling. So this allows applicants who were homeschooled to expedite the process. If they didn't have one of the 2 other documents, but they have the diploma, they can now supply that to licensing and we can move forward with their application process. So those are the rules that have to deal with licensing. Are there any questions about those particular rules? All right, now I'm going to move into a category I just kind of call general. These are 2 rules that went into effect. And the first one actually has no impact at all on you as a licensee community. And this one actually is one of the few restrictive rules that we have. And it's actually placed upon the commission. And this is that we cannot hire an outside contract lobbyist for the commission. Now, this in no way prohibits a commissioner or someone on the commission staff from advocating positions of the commission to any kind of governmental body, because sometimes that is necessary when we're trying to get legislation through. This just so that we avoid all appearances of impropriety, any kind of perception that we do not have a contract lobbyist that's advocating on behalf of the commission. And the next one involves our logo or our name and seal. If anyone moving forward wants to use our logo, our name, our seal in any kind of advertisement, any kind of website, anything like that, they must first seek permission of the commission. And this applies to anyone, not just licensees. It applies to the general public, other agencies. So if you want to use it or to continue using it, you would need to come before the commission and seek their permission and explain why you want to use our name or seal or logo in any of your materials. And that rule went into effect December 13th of 2021.